What's up, y'all? You're watching Union Minded, and today we are diving into our next installment of Contract Talk, the series where, if you're a member of Local 26, you and I read the contract together and try to understand what it is that we are reading. If you are a member of another local union, you get an idea of how to read your contract and try to understand the verbiage that may be in there. Before we dive in, don't forget to hit the like button, the subscribe button, ring the notification bell, drop some comments, share these videos, and let's grow the channel and grow the sphere of influence of solidarity and wisdom and knowledge in the labor movement and what it is we are a part of together. Now, because we are doing a reading situation, you already know my eyes is no bueno, de no es bueno. I gotta put on my glasses. So, here we go. Love it. All right. For my Lou Twinsies, my Local 26 siblings, get your contract. Now, where we left off last episode, we were talking about Article 2, employer rights and union rights, and we had finished up with Section 2.06. We were talking about employee contracting. We're going to continue from there. It's on page 7. So get your book, pause the video, open up to page 7, section 2.07, and we'll continue from there. All right, here we go. Workman's compensation. Each employer shall carry workman's compensation liability insurance as may be required by the laws of the District of Columbia, Maryland, Virginia, and any other state in which such employer performs work. Such insurance shall be obtained from a company authorized to do business in the state in which work is performed, and each employer shall furnish certification of its coverage to the union. Failure to comply with any portion of this section shall be considered a breach of the whole agreement between the employer and the union. So what this is telling us is that every employer, i.e. every contractor that we work for, has to have workman's compensation liability insurance that is through a company that is authorized to do business in the state where the job is being performed. And they have to give proof of this insurance coverage to the local union. And if they don't, it is a breach of contract and grounds to nullify the relationship. Section 2.08, medical attention. An employee injured while on the job shall be allowed sufficient time to obtain medical attention and shall be paid for time spent obtaining such attention, such pay not to exceed 2 hours. So if you do get hurt and you need to go to the clinic, you are paid 2 hours to go to the clinic. 2 hours. So make sure that it comes up on your check that you weren't shorted and not given those 2 hours that they are required to give you per your agreement to seek medical attention. Section 2.09, job accident reports. These are very important. It helps us to track how safe our jobs are, which is a very big selling point when you start to compare the union way versus the non-union way. So let's talk about job accident reports. Employees covered by this agreement shall report all job accidents the same day they occur to the job foreman, or when there is no foreman on the job, to the employer. So every injury, and you hear this from your safety department, every injury that you incur at work, you're supposed to fill out a job accident report and report it to your foreman, from the smallest thing to anything major. The job foreman, or when there is no foreman on the job, the employer shall then send without delay a written report or copy of the accident report to the employer's office and to the local union office when formally requested by the business manager or president of the union. So they have to maintain the record of the injury or the accident, and then if there's a reason that the business manager wants that information, they have to furnish that information and they have to have it available for them. Section 2.10, Joint Safety Rules Committee. The employer and the union shall each designate 5 representatives to the Joint Safety Rules Committee, who shall serve until their successors are appointed. We have an issue in the wording of section 2.10, and I will talk about it in a moment, but first we'll keep going. The committee shall meet not less often than once each year to review the OSHA safety standards and consider the application of these safety standards within the geographical area of this agreement. So the Safety Rules Committee is made up of 5 representatives, but here's where the issue lies. When we go back to Article 1, if you guys remember, we read in Article 1, I mean, not even in Article 1, before Article 1, we read, right after the Table of Contents, we read the Inside Wireman Agreement, in which it said, this is an agreement between the Washington, D.C. Chapter National Electrical Contractors Association and Local Union Number 26. It shall apply to all firms who sign a letter of assent to be bound by this agreement. And here's where the wording is off. As used hereinafter in this agreement, the term chapter shall mean the National Electrical Contractors Association, and the term union shall mean Local Union Number 26. The term employer shall mean an individual firm who has been recognized by an assent to this agreement. The term employee or employees is used hereafter to mean the worker or the workers that are covered by this agreement. So we are clear. Chapter means NECA. Union means Local Union 26. Employer means contractor. Anyone, free state, whatever. Employee means Local 26 member covered by this agreement. Okay, now let's go back to what we were just reading about the Joint Safety Rules Committee, section 2.10, keeping in mind employer, union, chapter, employee as your terms of labeling who is who in the agreement. So here it says again, the employer and the union shall each designate 5 representatives to the Joint Safety Rules Committee. Which employer? Is it Free State? Is it Rosendin? Is it Kelly Electric? Is it Aldridge Electric? Which employer is it that gets to name 5 representatives to the Joint Safety Rules Committee? And again, this is a legal document, okay? This is your contract. So words matter when you're talking about legalese. What it should have said, I think, is that the chapter and the union shall each designate 5 representatives to the Joint Safety Rules Committee, who shall serve until their successors are appointed. The committee shall meet not less often than each year to review the OSHA safety standards and consider the application of these safety standards within the geographical area of this agreement. That's how it should be worded, because I don't see how they could have possibly meant that one contractor was going to name 5 representatives to the Joint Safety Committee or the Joint Safety Rules Committee. I don't see it. So I think it's a mistake that needs to be corrected. Just because it's important to say what you mean and mean what you say when you're talking about contract language. All right, here we go. Section 2.11, employer telephone. An employer shall maintain a place of business with a business telephone. So if you're a contractor in Local 26, you got to have a place of business with a business telephone. You cannot just be like, that's no business phone. Just we'll write you an email. Section 2.12, work forms. The employer shall submit to the union office a work form for all jobs covered by this agreement that will take more than 1 week to complete. This form, furnished by the union, shall be a postcard form and shall contain the following information: location of the job, class of work, such as new, remodel, etc., and the approximate starting date. So these work forms are important because that's going to help us, help the union to determine how many job calls there are, so that they can put it into the posting for the membership. Section 2.13, termination slips. The local union shall furnish to the employer termination slips which shall state the reason for termination. 1 copy shall be given to the employee, 1 copy mailed to the business manager's office, 1 copy retained by the employer, and 1 copy sent to the NECA chapter office. The termination slip shall be signed by the job foreman, or when there is no foreman on the job, by the superintendent or other management representative of the employer. If the employee is not considered eligible for rehire, the completed termination slip will indicate that such ineligibility is for 6 months, for 1 year, or forever. A $20 payment shall be due an employee who does not receive a termination slip in his final pay at time of termination or layoffs. So that's where you'll hear it every once in a while. Get my $20 ready for when someone wants to lay a worker off without a check being on the job, or without a pink slip or a termination slip. And that's why they call it a pink slip, because your termination slip is pink. Your copy anyway. And so that's where the have my $20 ready comes from, because a $20 payment is due to the employee who doesn't get a termination slip and his final paycheck at the time of termination. Section 2.14, notice of vacancies. The employer shall notify the business manager of the union of all vacancies. Again, this has to do with job calls. You have one that has to do with upcoming work, and then another one that has to do with open vacancies. Section 2.15, management rights. The union understands the employer is responsible to perform the work required by the owner. The employer shall therefore have no restrictions except those specifically provided for in the collective bargaining agreement, in planning, directing, and controlling the operation of all of his work, in deciding the number and the kind of employees to properly perform the work, in hiring and laying off employees, in transferring employees from job to job within the local union's geographical jurisdiction, in determining the need and number as well as the person who will act as foreman, in requiring all employees to observe the employer's and or owner's rules and regulations not inconsistent with this agreement, in requiring all employees to observe all safety regulations, and in discharging employees for proper cause. In other words, this section 2.15 says, as long as what you're trying to do is not in conflict with the agreement, we as a union cannot tell you how to run your business. The only thing I will say that since it has to be in accordance with this agreement, then we need to be, as a union, very thorough in how we structure our contract, so that we don't have to tell you how to run your business, because if you agree with the contract, you're going to be doing everything just fine. The problem is when folks like to skirt the contract and then they're in conflict, and that's when it's up to the employees to raise these grievances, right? Because it's a grievance. Whenever it's a problem with your contractor, it is a grievance that you're looking to file. But that is when it is up to us as employees to reach out to our union and inquire about filing grievances for situations where they break down the conditions and break the contract. But that's on us to police that. Section 2.16 is going to be the last one that we do for this episode. Lending out. Employers shall not loan their employees to another employer. Sometimes they will try to loan you out to another contractor as a in the meantime thing. Section 2.16 prohibits this of Article 2. Do not allow these contractors to just pimp you out. It is forbidden in your contract. Keep that in mind when you're out there in the field. All right? My name's Eric. You're watching Union Minded. This has been an episode of Contract Talk. And I hope you found it informative and educational. Y'all keep in mind, the fight is not left and right. It is up and down. It's going to take solidarity to win always. Each one, teach one, get out there and reach one. And there can be no union without you and I front and center. You heard? Peace.